Mr. Chief Justice, and may it please the Court, my name is Jackson Ricker.
And my name is Finn Kessler. In past rulings, such as District of Columbia v. Heller, this court has created precedent by recognizing that outlawing the ownership of firearms is a violation of the protections guaranteed by the Second Amendment.
The Second Amendment clearly states that the rights to both keep and bear arms shall not be infringed upon. Through this argument, it will become clear to the Court that keeping an arm and bearing an arm are two completely separate, though equally protected rights under the Second Amendment.
After the bitter seizure of arms at Lexington and Concord, and the weak supply lines of Valley Forge during the Revolutionary War, the Founding Fathers were acutely aware of the dangers an unarmed populace presented to not only themselves, but to those around them. They recognized that militias were the largest fighting force the United States had at the time, and wished to protect the citizens' right to bear arms in case of another war in which we had to rely on ordinary citizens to protect themselves and their neighbors.
However, the Second Amendment does have its limitations. Necessary restrictions may be put in place to protect the well-being of the general public, such as requiring background checks to concealed carry a handgun outside of the home, in case of the applicant having an ill intent towards not only others, but also themselves. The requirement of completion of a gun safety course or a prior extensive experience of firearm use is also acceptable.
These restrictions, however, may lead to unconstitutional decisions. The refusal to accept the petitioner's concealed carry permits simply because they lacked an outstanding reason, also known as special need, is a clear violation of the Due Process Clause of the 14th Amendment. Neither petitioners had any criminal background, nor ill will, citing self-defense. Alongside, each petitioner had prior experience with firearms and the ability to handle them safely. Petitioner Robert Nash has applied the specific reason of wanting to keep himself safe due to a string of robberies being committed in his neighborhood. He has also completed a gun safety course prior to applying. Petitioner Brendan Koch's reasoning is a little bit more vague, only displaying self-defense as his reasoning, although he has extensive firearm experience.
The 14th Amendment states that no person may be deprived of, among other things, their property without the due process of the law. Because deciding what is and what is not a specific need for self-defense is up to interpretation, the petitioners were denied their 14th Amendment rights.
In Heller v. District of Columbia, the court recognized that the Second Amendment protects the right to keep and bear arms as an individual right and for self-defense. As stated before, both petitioners have the reasoning of self-defense as to why they should have a concealed carry permit. Heller v. District of Columbia also cites United States v. Miller, saying the traditional militia, mentioned in the Second Amendment, was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. Commonly used weapons at this time would be handguns, which affects concealed carry permits and the requirements for obtaining one. Thomas Jefferson, one of the founders, has also expressed his intent when writing the Second Amendment in his letter to Destutt Tracy, saying that the militia of the state, that is to say, of every man in it able to bear arms. This is implying that at least one of the founders had a more broad interpretation of the Second Amendment, which aligns with the previous ideals and decisions of this court. This establishes a precedent that must be followed if we wish to adhere to the Constitution and its intent.
Furthermore, McDonald v. City of Chicago establishes the further precedent that the Second Amendment is no second-class right, subject to an entirely different body of rules. The other Bill of Rights guarantees that the court has held to be recognized into the Due Process Clause. Because of this ruling, New York is beyond its power in denying the petitioners concealed carry permits on the basis of them having no special need. The strict and selective process that requires citizens to demonstrate a special need for a permit treats the Second Amendment as a second-class right, as it implies that the Second Amendment right to bear arms does not apply unless specific requirements are met. As there is no strict process for selecting or denying these permits, the petitioner's Second Amendment rights, as established under McDonald v. City of Chicago, were denied. I respectfully remind the court that the petitioners are upstanding members of society, responsible firearm owners, and that they lack any criminal records. They merely lack an extreme circumstance by which their rights could be applied. Because they live conventional, normal lives, their guaranteed rights are being infringed upon.
This court must recognize that the right to keep arms and the right to bear arms are two separate but distinct guarantees that must be protected, and are, under the Second Amendment. If someone could bear an arm without the right to keep it, it would be illogical, as simply bearing the arm would already imply having one, and thus would not be protected. Similarly, if someone could keep an arm without the right to bear it, it would be keeping nothing more than a decoration for display purposes only. Because the Second Amendment specifically covers arms, it can be reasonably understood that they are meant to be used, or else their ownership would not need to be protected as a fundamental right. We remind the court that above all, the founders feared a tyrannical government, and having fought in a revolution against a tyrannical government, they understood Locke's ideals of fighting an oppressive government should the need arise.
Furthermore, it can be generally understood that possessions are stored within the boundaries of one's property or home. In the lower court case, Wren v. District of Columbia, the judges make reference to the definition of bearing arms, citing District of Columbia v. Heller. They claim that the court elaborates that to bear means to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person.
We hold the definition of keep to be self-explanatory. To keep is to maintain in one's possession. It can be reasonably understood, given these descriptions, that bearing an arm extends well beyond the home, the place in which possessions are typically held, as the ability to wield an arm solely within the home would be, in essence, keeping an arm, with the exception of the rare cases of self-defense within the home. As the Second Amendment does not limit the right to bear arms to within the home, it must therefore be interpreted broadly, extending its protections to beyond the home.
The framers lived in a dangerous, isolated world. A great many people lived in desolate, rural areas. Even more had to travel days, weeks, or even months-long journeys throughout the countryside or across the sea to reach populated cities. Roads being vast, remote, and unguarded, the need for one to protect themselves outside the home would not have been unrecognized by the framers. Instead, it would have been a major intent behind the Second Amendment.
Through the distinction being made between keeping and bearing arms, it should be clear that both the right to keep arms and to bear arms are separately enforced. Although the petitioner's right to keep an arm was not violated through the refusal to issue to them concealed carry permits, the right to bear arms was.
Lower court decisions, such as the aforementioned Wren v. District of Columbia, affirmed that it is, quote, natural to view the amendment's core as including a law-abiding citizen's right to carry common firearms for self-defense beyond the home. The petitioners are law-abiding citizens. They had no criminal records, and they were motivated by self-defense. Given the criteria already met by the petitioners, it is highly unlikely that in practice there would be a difference between the open carrying of a firearm and the concealed carrying of a firearm, beyond the fact that for a law-abiding citizen, concealed carry, by nature, is less confrontational and thus safer.
Furthermore, the New York law refuses applicants the issuance of a concealed carry permit should the reason for obtaining one be their proximity to a high crime area. We remind the court of their decision in McDonald v. City of Chicago, wherein it was made clear that, and I quote, petitioners and many others who live in high crime areas dispute the proposition that the Second Amendment right does not protect minorities and those lacking political clout. The number of Chicago homicide victims during the current year equaled the number of American soldiers killed during that same period in Afghanistan and Iraq, and that 80% of the Chicago victims were black. Amici, supporting incorporation of the right to keep and bear arms, contends that the right is especially important for women and members of the groups that may be especially vulnerable to violent crime. End quote.
As such, it is again clear that the New York law is a clear violation of the Equal Protection Clause of the 14th Amendment. Because of the disparate impact of the New York statute, the case must be examined under strict scrutiny, and the court must recognize that the decision not to allow the petitioners concealed carry permits was a violation of their Second and 14th Amendment protections.
Given the clear constitutional violations that have ere been elucidated, we plead that the court hold that the refusal to issue concealed carry permits to the petitioners is unconstitutional. We thank the court for their time and pray they find our argument a compelling voice of reason.